Yes, thank you. Good afternoon, everyone. Naturally, I'd like to start by thanking the Catholic University for the hosting and carrying out this event. It is a university in which I never talk, but I'm very close to it. I've done many things here, and I have many friends here, so I always feel very good at this university. And naturally, I'd like to greet my colleagues of the table, and starting with Dr. Swarsh, we already knew, and other participants. I was a little bit envious, but I'm not able to do what Philip Marx did. He greeted individually maybe 2,000 people, but I'll save your time and let me repeat his greetings and consider yourselves greeted naturally, otherwise I'll not be able to say anything worthy in my time allotted to me, and I don't want to overstep it. Naturally, let me also thank particularly the fact that we are here is from the interference of Paul Pinto Albuquerque. I'm not a magistrate by career. I'm a bit of an outsider here. I can imagine that most of you present, or most of you are magistrates. So I'm an amateur in the middle of professionals. Let me start my brief remarks by saying precisely the conditions in which I prepared them. And I presume that you can imagine my time has limitations. My day is also only 24 hours like yours, and the limitations inherent to my office limited the commitment that I could commit to this intervention. And therefore, this explains, maybe it doesn't absolve me, but it explains the erratic tone of my considerations, since I didn't have time to order and systematize my reflections. And obviously, to this we add the fact that I'm not a magistrate by career, which makes it difficult to have a correct perception of the problem of the independence of judges, not because I'm not aware of the decisive importance of it, but not because I don't have the indispensable experience in the field. These very circumstances explain that I couldn't have included in the adequate places of these remarks the precise indication of my sources. I used mainly documentation from the services of the European Commission, the Consultative Council of the European Judges, Amnesty International, and articles published in the Journal of International and European Law, to which we added occasionally news from the media. I ask you naturally for your indulgence if there is some imprecision or mistake resulting from very quick readings and likely faster conclusions. As a starting point for the approach of the judicial, Article 203 of the Constitution of the Portuguese Republic, I'd like to start by saying that the courts are independent, are only subject to the law, not limited in our fundamental law is this solemn proclamation. The main instrument of the guarantee of the independence of judges is in number 1 of Article 216. Judges are immovable. They cannot be transferred, suspended, forced retirement, or forced into resignation, unless in the cases foreseen in the law. Notice that when I refer to the law, to the non-Portuguese here, because Portuguese know this well, this implies paragraph M of Article 164 of the Constitution for the concept of parliamentary law, the law of the parliament, because in Portugal, as we know, we have laws, the true laws of the government, but of the government, the legislative competence of the government is not a rule. In Europe, it's rather an exception. That's why this explanation, this law is parliament law. It is law of the parliament necessarily. So this proclamation of the independence of the courts, followed by the indication of its main guarantee, is far from being something original of our constitution. Choosing 3 countries that are close to us regarding law, we find constitutional formulations, 2 before our constitution and 1 after, that are very similar. Therefore, the Spanish Constitution of 1978, in numbers 1 and 2 of Article 117, highlights also the independence subject to the law and immovability of judges. The same happens with the Fundamental Law of Bonn, which in its Article 97 also guarantees independence subject to law and immovability of judges. On the other hand, the Constitution of the Italian Republic of 1947, in its Articles 101 and 107, also highlights the exclusive being subject exclusively of the judges to the law and its immovability. If this sample is significant of the situation and also the juridical and constitutional tradition in Europe, which I think it is, I'll be able to conclude reasonably safely that the independence of judiciary power, a fundamental guarantee of the rule of law, covers, regarding judges, three main vectors: their independence, the exclusive subjection to the law, and their immovability. Trying to discover these concepts, firstly, through the independence, we need to understand the freedom of the judge to decide freely. In other words, based on their convictions, their knowledge, and their experience, all the questions of their competence. Not, of course, forgetting, obviously, that the judge cannot abstain from judging. Otherwise, he will be denying justice. Putting this freedom into effect demands, on the one hand, that the judge does not suffer any kind of pressure. Suggestions, and I put suggestions in inverted commas, threats, interference of any nature of whoever, namely the other powers of the state. On the other hand, it implies the immunity of the judge regarding criminal or civil cases that try to make effective their responsibility for decisions taken by them. Regarding this, we need to criticize the common practice of the disciplinary section of the Supreme Court of Poland to withdraw immunity of judges, to allow for the opening of criminal procedures against them, a lamentable method of trying to influence their decisions. The independence of the judge is put into question when, namely, those responsible for the state promote or allow to promote reiterated attacks in the media against judges and their decisions, as we have seen in Hungary, and it already happened in Portugal, let me remind you, and not very long ago, when the constitutional judges in Portugal were threatened by members of the government at the time and by the press connected to the coalition that supported them with disciplinary process for having decided to invalidate decisions taken by the government during the period of the intervention of the Troika in Portugal. The independence of the judge is equally put into question when a legislative alteration in Slovakia introduces the impossibility of making a judge accountable for having issued one, and I'm going to read in Portuguese, the English translation, because I don't speak Slovenian, because I don't Slovakian, I don't know if it's difficult to understand. A legal opinion expressed on a judicial decision, unless it implies the practice of a crime. Whatever this means, because I don't really know the reach this says, that is not a clear result of the translation in the English language. Legal opinion expressed in a decision, unless a criminal offense has been committed thereby. Whenever this happens, the articulation of this norm, like the one it defines in the new crime, bending the law, that we could translate to force the law. I don't know how to translate this, which determines that this bending the law happens when the judge supposedly, and now another translation into Portuguese from the English, applies law arbitrarily. This combination of these two things by the definitions creates a space of imprecision and doubt that we have to censor. It would be difficult to find a more obtuse and dark way of corroding the independence of the judge. And the independence of the judge is still put into question when we disseminate or promote the dissemination of intrusive information on judges, namely regarding the political past, with the aim of discrediting them because supposedly they have collaborated with an authoritarian regime, as we see in Poland. And the independence of the judge is once again put into question when a body or political appointment systematically contradicts a representative body of the magistrates, as we see in Hungary, within the realm of the conflict that opposes the judicial office, connected to government, to the National Judicial Council, an independent body, in terms of selecting the presidents of the courts. Note that the president of the National Judicial Office, as a rule, annuls the procedures of the selection of the judges promoted the National Judicial Council and appoints the interim presidents for courts that are in function in the meantime. B. Being subject to the law implies that the judge should respect and apply the legal norms in force from different sources, deciding autonomously according to the principles and rules of interpretation and integration in force in the juridical ordainment and according to their conscience. We are all jurists and we know how common it is to diverge in interpreting the law. In Portugal, some actually say that if you have 3 jurists in a room to discuss the interpretation of a norm, and we will have 4 opinions. The autonomy of a judge to decide the applicable law is not separable from the independence, and also the irresponsibility in countries that don't have binding precedents, as we see in the common law countries. We have an admissible and instrumental legitimate interest that on behalf of juridical security and in the certainty of applying the law, they try to reduce the interpretive divergences of the judge by fixing good law. It is a point that such mechanisms be bound in the perimeter of the judicial power and as much as possible do not offend the autonomy of the inferior courts. And obviously I'm thinking, when I read this part of the text, in the appeals for the uniformization of a case law in the several cases that were in Portugal. Regarding the immovability of judges, this has several aspects. It implies right from the start that judges cannot be transferred from a court unless in the cases expressly foreseen in law. The immovability is disrespected when we change the composition of collective courts already comprised, as we have done or is still done in Poland, or when we transfer unilaterally and compulsively judges from one court to the other, as we see in Slovakia. It implies, secondly, that judges cannot be suspended from their functions outside the cases foreseen in the law, namely for reasons of disciplinary nature seen in a course of due process. And this implies, at least, besides the respect for the contradictory and adversarial situation, for the presumption of innocence and existence of an appeal. Thirdly, it implies that the judges cannot be compulsorily retired unless because of the limit of age for reasons of health duly proven through the form legally proven or as a consequence of disciplinary breaches for which they were found guilty after conclusion of due process. Lastly, it implies that judges cannot be resigned from their functions unless for disciplinary reasons, also after a due process. And let me highlight that this due process in the processes that are susceptible of affecting functions of a judge is not always respected, as seems to be the case regarding the processes that occur in the disciplinary section of the Supreme Court in Poland. In the cases in which a judge carries out their functions for a period of predetermined time, this term cannot be anticipated unless in the cases foreseen in the law. The anticipation of the term of the mandate for reasons of opportunity or political convenience gravely puts into question the immovability of the judge. This seems to be the situation in Slovakia after the last constitutional revision. My understanding of the juridical framework of the independence of the judiciary or the courts or the judges, whichever way you prefer, also recommends 4 other points. Firstly, that judges cannot be appointed by the government or with any intervention of it and can progress in their career in function of merit, duly assessed by other judges or other bodies in which they are duly represented. Secondly, that the presence of the higher courts be chosen by their peers without intervention of any other body of sovereignty. Thirdly, that the judicial magistrate has its own bodies of government. Lastly, that in these bodies, the majority of the members are not appointed by the government, nor according to political criteria. And it seems to be precisely this that happens in Poland. And just to end off, I would like to leave you like an epilogue, a very personal message for judges. The guarantee of their independence recommends highly, in my understanding, that the judges conserve a prudent distancing regarding those that influence public opinion, maintaining reservation about their opinions. I confess that I don't particularly appreciate judges that come on TV in prime time answering questions of journalists on problems of courts. When a judge takes on the body of a commentator in the media or social networks, it is a dangerous step for independence. The duty to inform public opinion, which I obviously acknowledge, should be complied with in an institutional way and is not aimed at feed gossip nor morbid curiosities. Thank you for your attention.